Stand by. Hello, everyone. This is Sarah with Connect Our Elders, and today I have Rod Hatley, Managing Partner of Hatley Law Group. Rod, it's so great to have you on the podcast today.
Sarah, thanks for having me. I appreciate it.
You're welcome. So for those of you that aren't familiar with Rod, he is former Navy JAG, and he's been a personal friend of mine for many years. Extremely thoughtful individual and very detail oriented. And so, it's no surprise that he's so talented and so thorough with his clients in his estate planning and asset protection practice. Matter of fact, actually, before I deployed, Rod made a point to get my daughter a little stuffed bear that would help her get through us being separated. So that has continued to mean so much to us, Rod. Thank you. We're going to get started now, and I have a few questions that I'm going to ask Rod that is going to help us understand, estate planning is always important, but it's seeming that in these times of COVID, the importance has increased. And so we're going to address that as well as get into some more specific questions around estate planning and documents. So starting off, in this time of COVID-19, what documents should our elders have at their disposal?
Excellent question. And I guess really the best way to answer that, Sarah, is to say that everyone should have an advanced healthcare directive. Now, I'm a California lawyer, so I don't know, this will probably be seen by people across the country, I suspect, but at least an advanced healthcare directive here in California, and other folks would probably know it as a healthcare power of attorney. And then, of course, a HIPAA authorization. And those two documents are really key. So in the event that an elder may need to go to the hospital, then they've already thought through, well, what happens if I don't make it? Or if I'm in a persistent vegetative state or an irreversible coma, what do I want my agents to do on my behalf? So those are great documents to have. The Advanced Healthcare Directive handles those medical decisions, and the HIPAA authorization allows your agents to have access to your protected medical information and be able to talk to the doctors and nurses so they can make those informed choices.
And very true. And given my experience with working in the elder care industry, we see these situations where people have not proactively planned, and then it delays the ability for them to be helped when there is an emergency or something happens. I would like to stay on that question for a bit more, making sure that they have their healthcare directives. So let's talk about how specific they should be. So is it enough for someone just to tell their significant other, for example, if I go on life support, pull the plug, I don't want to be? Because what if there's adult children involved?
Oh, sure.
And they don't agree? So how specific does this planning need to be?
Well, I mean, it's fine to tell someone orally, but here's the challenge with that. You may remember a case some years ago where a woman, I think, had a heart attack, and she was deprived of oxygen to the brain. And so she had told her husband, at least reportedly had told him, I'd only kept alive artificially. The challenge was nothing was ever written down. So her parents got involved. And so they actually, tied up everything in court, which is not, what the lady had wanted to have happen. But that was the practical result of not committing something to writing and making it clear that in the event that I'm incapacitated and I'm on life support, I don't want to be kept alive artificially. So the sooner clients can get this written down and memorialized, number one, it makes it really clear to the outside world, this is what I want to have happen. And it also takes the burden off of the family to make those gut-wrenching decisions. What do I want to have happen if something happens to me like that?
That's a really good point, Rob, because, usually when I'm having these conversations with people, they, if they do even understand the importance of the planning process, then they're not getting the fact that they are truly taking that emotional responsibility from their loved ones, not having to debate internally back and forth if the time comes on what is the right thing to do. So, so making sure that these are put in place. I've seen it, you've seen it. It is of utmost importance to make sure that you do this planning.
Absolutely.
Okay. So moving on, what do you recommend your clients do with their important healthcare documents, and where should they keep them?
Okay. Well, I mean, obviously, I always recommend to clients, get a good estate plan, put it in place, keep it updated, and keep it maintained. Okay. For the healthcare directive here in California and anywhere else, it'd be probably known as the healthcare power of attorney. and the HIPAA authorization. What I do in my practice is I buy my clients a membership, a 3-year membership in a company called DocuBank. And I'm not here to shill for DocuBank. I mean, they do great work, but I have it for myself, and I also get it for my clients. It's not optional. They're going to get it if they work with me. It's a 3-year membership in DocuBank. And what happens is I provide a copy of their healthcare directive and their HIPAA authorization to DocuBank. So, and they get a card that I ask them to keep in their wallet next to their health insurance card and their driver's license. And this card says that in the event that I'm, hospitalized and I'm unable to speak for myself, call DocuBank at this toll-free number. You can call them 24/7, 365, and a copy of, in my case, my healthcare directive and my HIPAA authorization can be faxed over to the hospital. And then my agents can be contacted and they can show up on the scene and make those important decisions on my behalf because I can't. So, because, let's face it, in the event of an emergency, and remember, nobody walks around with a copy of their healthcare directive and their HIPAA. It's just, let's be honest, nobody walks around with a copy of that on their person. But
Right.
if we have access to it in an emergency, well, even if you knew where it was, the last thing you're thinking about is, I got to find Sarah's or Rod's healthcare directive and HIPAA authorization.
Right.
You got to get to the hospital. That's your main focus. And then when you get there, it's like, okay, I didn't get the HIPAA and the healthcare directive. What do I do now?
Mm-hmm.
You're not going to, remember orally. You're going to call DocuBank because they've got the card and they're going to fax over a copy of the document so you can make those important decisions in the moment. Okay.
Correct. Well, thank you for that information, because I've actually never heard of DocuBank, and that's wonderful that you do that for your clients. That's definitely
optional. It's a given. If they work with me, they're going to get it, and I think it's important. I make it good for 3 years because in about 3 years, I'd like to have the clients come back and see me so that we can review their planning, make sure it still meets their needs, because the laws are going to change, their personal situation is going to change, my experience as an attorney is going to change. So about every 3 years or so, we should be updating their plan anyway, or at least taking a look at it and make sure, does it still work for them? And then, of course, renew their DocuBank membership so that they've got that peace of mind.
Mm-hmm. Well, that's great. So some elders already have a will. And we're saying elders because obviously this is the Connect Our Elders podcast, but this applies to any adult, right, regardless of age. So if you have a will, does that mean that you would avoid probate just because you have a will?
No. Here's the big insight. Wills are a guaranteed ticket to probate court. So for those of the listeners who don't have any kind of planning, you're going to go through probate when you pass on someday. And for those who do have a will, a simple will, that's a guaranteed ticket to probate court. So I guess the best advice I can give is if you own real property, at least here in California, it makes a lot of sense to have a living trust and put the home and any other real property you may have into the living trust so it'll avoid probate. And just to give you a very quick example, here in California, here in San Diego, where I live and practice, let's say someone has a fair market value home at $1 million. Forget what the equity is. Let's just say the fair market value is $1 million. The statutory probate attorney's fee and the personal representative's fees, when you combine them on $1 million property, is $46,000. So call it 5% of the value of that asset is going to go to statutory attorney and probate personal representative fees. So that can all be avoided by having a properly drafted and funded, and when I say funded, I mean transferring the assets into the trust, estate plan. So wills are fine, but the problem with wills is they only become effective when you die, and they guarantee you going through probate court. So if you have a living trust, a trust is valuable for two reasons. Number one, I'll pick on myself. If I become mentally incapacitated as a result of an injury or a disease, then if I hadn't done any planning, and so that I have, but if I hadn't, at some point, someone's going to need my signature. And the way they get is they put me in front of the probate court judge downtown. They say, Your Honor, this is Rod. He's incompetent now to manage his affairs. Please appoint me, some third person, to be his conservator, which is really a guardian for a grown person. And so guardianship takes time. It costs money. It's a matter of public record. It's in the probate court, and we sometimes call that a living probate. And then, of course, someday when I die, guess what? probate because all I had was a will, or maybe I had no planning at all. But if I have a living trust, no conservatorship, and if I put my assets or funded them into the living trust, no probate.
No probate. And, it's people have this common misconception that you need to have significant assets, let's say 500,000, $1 million for
Sure.
it to be important to have a trust, but that's not actually the case. What is the dollar amount? If you own a home or if you have children, right, you need to have a trust, is my understanding.
I'll say it this way. I mean, if a client has a home, I really recommend that if they own their home, and certainly if they've got a mortgage on it, they may not own it free and clear, but if they've got a home and they're paying a mortgage on it, I think it's a great idea to have a living trust. Put the real property into that living trust, and it will also take care of you not only when you pass away to avoid the probate on that asset, but also to take care of you while you're alive, but maybe you're not well, mentally incapacitated as a result of an injury or a disease. Sure. Now, if it's a situation where a client may have children, but they don't own a home, certainly a standalone will supplemented with a power of attorney, healthcare directive, and a HIPAA authorization and a DocuBank membership, I think can make a lot of sense because they can say, well, I don't really need to avoid probate because, I don't own a home, but I do want to provide guardians for my children if they're minors, if they're under the age of 18. So, but once they acquire that first home, or if they have maybe $200,000 or more, say, in assets, maybe a bank account, brokerage account, or more typically a brokerage account, then I think a living trust can make a lot of sense. But for very modest estates, I think a standalone will supplemented with the other documents would probably be enough. But it's all on a case-by-case basis, and I'm talking very generally here, and every client situation is different, so it just depends on what's important to the clients and what their objectives are. So I hope that's helpful.
It does. That is helpful, especially regarding the property. And if you don't mind, I want to talk a bit more about the children factor.
Sure.
So, even if we're specifically talking about elders and the estate planning for them, I've had numerous clients who have adult children with disabilities. And so, we could have these situations where maybe it's a younger couple and there's no other family. And so, first of all, let me stop for a second. What happens to children if, for example, both parents are killed in a car crash? What happens to the children?
Well, ideally, they gave some thought to nominating guardians, possibly in a standalone will. But if they didn't, then next of kin would have to be contacted, and they'd have to petition the court to be awarded, guardianship of the children until the kids turn 18. And so it can really be a challenge, and that's all the more reason if clients have young children. It's a tragedy, obviously, to lose both parents, but then you compound that by not having thought through, well, who would I want to take care of my kids, love them, raise them, etc. So all the more reason, get out ahead of this, think through it. Who do you want to serve as the guardians of your children? And at a minimum, at least have a will in place to nominate those guardians. And of course, when I work with clients, if we do a living trust, we'll do a will as an additional document, and we'll nominate guardians in that will, and that's usually the best place to nominate the guardians. But whether it's a will or a standalone will or a living trust supplemented with a will, great idea to nominate guardians in that document.
That's good information, and the reason why it came to mind is because in the past, Rod, I think I was meeting with you at one of your former offices, and we got onto a discussion about if guardians are not selected, there is the potential that before a next of kin can petition the court, that the children would go into the foster care system for a period of time, which could be just add to the trauma.
Absolutely. All the more reason, I plead with clients, please get out ahead of this. You're only going to compound the situation because the kids have to go to a halfway house or foster care until such time as guardians or prospective guardians next of kin can be contacted and then show up on scene, petition the court, et cetera, to be confirmed as guardians for the kids. So, and I think any responsible parent obviously wants to prevent that, but I know we're all busy folks, and this pandemic has certainly made that even more challenging, parents trying to work from home, take care of their kids, and et cetera. So all the more reason, please get this planning in place. The sooner the better. Give you peace of mind so that if something does happen, your kids are provided for.
Right. And, one last thing on that particular question. So, bringing it back to, let's say, the elder demographic,
Okay.
and the ones that do have adult children with disabilities. And during these COVID times, maybe they're more fearful that they might get it and their health be compromised. It's even more important. So would they do a special needs trust for that adult child with disability?
They could, certainly. And that's a counseling issue, certainly, as we meet with clients and to make a determination. I mean, if there's a child has autism or there's some kind of special needs so that they are receiving governmental benefits, if mom and dad leave an inheritance to that child through their trust or their estate plan, whether it's a will or a trust, and they didn't leave it in a special needs trust for their benefit, the tragedy is the special needs child will lose his or her governmental benefits, the SSI, the Medi-Cal, et cetera. Then they have to spend down through their inheritance, which is an absolute tragedy, and then they have to go requalify for the Medi-Cal and the SSI. That's all avoidable, and you don't have to put your family through that. So all the more reason, if we've got a special needs child, let's have a conversation about how we can set up an inheritance to go into a special needs trust so the money is available to be spent to enhance and enrich that child's life, but it won't be an asset that they can control, so therefore they lose their very valuable governmental benefits.
That is such an important factor. I'm
Yes.
glad that we were elaborating on that.
Sure.
We do have some comments right now. So let's see. One of my colleagues, Tammy Moses, she's the founder of Hoarding Solutions. So she helps people that have significant hoarding problems because usually hoarding is not so much about just collecting things. Usually there's a lot of emotion attached to it.
Absolutely.
She helps people work through this.
Right.
But she was saying, her question was, what is a good resource to create a trust? That would be you, right, Rod? You do the trust?
Well, a couple of ways you can attack that. One way is certainly, and you have people all over the country watching this today. So in your local area, you've got a bar association. There is a lawyer referral line. So you can contact the lawyer referral service at your local county bar association, and they can give you at least 2, possibly 3 referrals to an estate planning attorney in your local area. And I think you're entitled to a free half-hour consultation. And if you like the person you're meeting with, terrific, then work with them. If you don't like them, fine. You may have 1 or 2 other referrals that you can go talk to, and work with someone that resonates with you. You like them. They answer your questions directly and fully. And if that's the case, then I think you'll enjoy working with them. Or if I can be a contribution, certainly feel free to reach out to me. I'd be happy to hear from you to see how I can be of contribution.
Great. And we had another comment from a Jason Barbier. I'm not sure if I'm pronouncing that right, but he was saying that we're having a smart discussion. So that's flattering. For those of you that are watching, Rod is one of the smartest individuals that I've met. So I assure you, he knows exactly what he's talking about right now. Real quick before we move on to the next question, I think it might be of value for you to share your personal story as to why you can so passionately speak to the importance of doing this planning.
Yeah, I mean, for a lot of estate planning attorneys, they may have transitioned out of litigation because it was really time consuming for them, and this was a more reasonable practice area. And for some, it's just an intellectual exercise, and I get that, and that's fine. For me, this is really personal. My father had a simple will, and as we've already shared, wills go through probate. Unfortunately, in my case, it was a 7-year probate back in my hometown of Memphis, Tennessee. And that's
7 years.
7 years. And that's not what Dad wanted, but that was the practical result of his dad had leukemia. So at that point in his life, he was making emotional decisions, and you understand. But I just decided there had to have been a better, smarter way to do this than going through a multi-year probate. So when I came off of active duty in the Navy JAG Corps, I went and got an additional law degree and then transitioned into estate planning. And for me, I mean, I enjoyed my time in the Navy as an attorney. Was good at it. I was a criminal defense attorney, so if you ever saw A Few Good Men, that's what I used to do. But I was always in a reactive mode. Now I get to be proactive, and I like that eminently better. So and for me, this is real world stuff. This is personal for me, and I don't want my clients to have to go through a probate of any kind. So that's my goal when I work with clients.
Yes. And I feel that every time we have a discussion about that. So I'm confident that when you're interfacing with the prospects and the clients, that they also feel that same sentiment, Rod.
Sure.
So next question.
Okay.
How often should an elder's estate plan be reviewed?
Well, I would hearken back to the DocuBank membership that I get for all of my clients. It's I make it good for 3 years, and ideally I get the clients to come back within 3 years, but they don't have to come back if they don't want to. But I hope that they will. And about 3 years is long enough because there may have been changes in the law, tax law, changes in their personal situation, changes in my experience level. So those are all good reasons to have the clients come back in about 3 years, and ideally not more than 5 years. Of course, some clients never come back, and that's fine. I have to earn I have to earn the right to get their renewed business. But
right.
Bottom line is, I'd like to see them, every few years or so. So about every 3 years, I think, is about the right length of time for them to come back in and see me.
That's great. Every 3 years, I was having a meeting yesterday with a private fiduciary
Sure.
based in San Diego, Marguerite Lorenz
Sure.
from Lorenz Fiduciary Services. And we were talking about the importance of reviewing the documents. And we were talking about the 3 years being, that's the longest you want to go.
I think so.
But also we got into, even aside from tax laws changing, I'm not an attorney, so is it the gift and estate tax exemption law? I don't know what to call it, but you know what I'm talking about. So, regardless of that or major life, having more kids, but you hear of these horror stories where somebody's been divorced from their ex-wife, for example, for let's say 20 years, they got remarried totally happy, and then something happens, they pass away. And then the former wife is still the beneficiary
of course.
Some of the assets. And so this would be part of the review process, correct?
Absolutely, yeah. And we work with clients to make sure that the beneficiary designations on life insurance, retirement plan monies, et cetera, are updated to reflect their new situation. And it's not unusual. And clients are really meant to do it, but they got busy, life got in the way, and then suddenly they're out of the picture. And now, unfortunately, and it's all by contract. I mean, the beneficiary designations were never changed or updated to reflect the new spouse or whatever the situation is. And so now the former spouse gets the life insurance or the retirement plan monies, et cetera. And that can be really maddening, but that's, if the clients don't take the initiative to do it and they won't work with us, then that's up to them. But we do everything we can to drive them to make these changes as soon as possible.
Right. I also think, doing the review. So let's say if a couple has multiple children, right? And, they do the planning, but then circumstances change with, let's say, one of those children, and they realize, okay, maybe for that person, we can't give the same, not amount wise, but perhaps they need to now implement a special needs trust because of whatever situation. And so, I have just experience with dealing with many families over the years, that the ones that did the proper planning, and when one of the elders passes away, it really helps to mitigate the conflict between the children if they made their wishes very specifically known as to what they want to have happen upon their passing.
And that's all the more reason why it's so valuable to get out ahead of this and make it really clear. And what I tell clients is, treating the children fairly does not necessarily mean treating them equally. And there may be, especially if there may be possibly mom and dad have a small business or a business that they run that's been very successful, and one of the kids possibly is involved in the business. And so we try to do equalizing distributions to the other children because the one child who works in the business is going to get the business. And so we try to balance that out. But just because we're treating them fairly doesn't mean we're necessarily treating them equally. So that's a point I try to make clear to the clients. But to your point, if there is a child who has special needs for whatever reason, let's make sure that we get out ahead of that and set up a special needs trust that would that would spring into existence when mom and dad, pass on someday, so that the inheritance that child would receive will not disqualify them from their governmental benefits.
Right. I've never quite heard it put that way before, where the term equal is kind of relative, meaning, being treated fairly doesn't mean that it's in equal amounts.
Sure.
That's a great distinguishing point.
Sure.
Thank you. Okay. Last question, Ron.
Okay.
If an elder would like to visit with you to review his or her plan that they already have or their current situation, what is it that you charge them to do this?
I don't charge them anything. The bottom line is I don't even know if I can help them. So all of my meetings, whether it's with a existing client or with a prospective client, are all complimentary. I don't charge anything for the meeting. And so when we come to the conclusion of the meeting, if I can be of contribution, I'll say, well, here's what my fee would be to move forward. What would you like to do next? And then it's up to them. If they want to move forward, that's fabulous. If they don't want to, or it's not the right time, or I'm not the right attorney, that's okay. I want them. I hope that because we spent the time together, they're smarter for the conversation that we had. So even if they ultimately, and this is for really more for prospective client, if they ultimately end up working with another attorney, then my goal is when they leave the office, they're smarter because of our conversation. And now they're empowered, they're in the driver's seat. And if they're working with another attorney, they can say, well, I want this or I want that. And so now they're a lot smarter about what their options are, and they can make an informed choice. Hope that helps.
That resonated with me so much because you're using the term empowered.
Yeah.
And the fact that you're looking at it like that really resonates, because the tagline of Connect Our Elders is empowering aging. You know, and so what you're doing is empowering them to make the right decision, to do the planning, regardless of if they go with you or not. It's empowering them to take care of themselves is the bottom line of what we're doing, which is super important. So Rod, if somebody has an estate planning need, or if they want to sit down and do a review with you, how can they contact you and get something scheduled?
Sure. Thanks for asking. And if anybody would like to reach out, I'll give you 2 points of contact. The office phone number is area code 858-465-8002. 858-465-8002. Or if they want to send an email, they can certainly feel free to reach out to me at Rod, R-O-D, at Hatley, H-A-T-L-E-Y, lawgroup.com, Rod at HatleyLawGroup.com.
Okay, thank you so much, Rod. Everybody that tuned in, we really appreciate you listening. If you have questions, Rod provided his information, but if for some reason you didn't catch that, feel free to reach out to me and I will certainly provide an introduction for you. We have one last comment from the audience saying, empowering them to ask the questions and make decisions. Elders really need that. And Tammy, thank you so much for that comment, because that is the entire point of Connect Our Elders, and Rod is of the same philosophy, which I really appreciate. As a reminder, I am Sarah. I'm the founder of Connect Our Elders, and Connect Our Elders' mission is to empower the aging process through education of resources, helping elders navigate those resources, and being an advocate to choose what the right resources are, and then implementing a plan to move forward. So thank you for tuning in today. And if you have any questions, please reach out to myself or Rod. Thank you very much and enjoy the rest of your day.